For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Matthew Motley, representing the plaintiff, Kristen. Is it Keister or Keister?
Keister.
Keister. Good morning, Ms. Keister. In addition, Attorney George Ontropolis.
Perfect, Judge. Thank you. Yes.
Good morning, Mr. Good morning, sir. Is present representing the defendant, Dwayne Henning, and Mr. Henning is present. Good morning. I know the parties conferred with Mr. Walker for the front of the court this morning. Do the parties have any resolution or agreement?
We've agreed to return to mediate with Mr. Walker on July 24th, Your Honor, at 1:30.
That is correct.
Mr. Motley, that's good with everyone's schedule?
Yeah, we plan to just use this time to exchange some documents. I don't think this is going to be a lengthy discovery period at all, but we obviously want to reduce the cost for everyone involved. We'd like to mediate with the FOC, have a chance to exchange some basic employment information just so that we can go in there and try to resolve it all on that date.
Well, of course, one solution is we can, if parties can agree upon custody and parenting time this morning, we can refer the issue of child support to the front of the court for a formal investigation recommendation. And typically they'd get financial documents from both sides. They'd issue a recommendation. Each side would have 21 days in which to object to that recommendation before it became an order of the court. That is one very efficient solution. But
Your Honor, I know the parties have been operating. There is no order, as the court's aware, but they have been operating on a parenting time schedule. We would be in favor of that, but I can't speak for Mr. Motley and his client to continue that schedule and reduce that to an order. But I think that may be an issue for the other side.
I would, yeah, if the court's inclined to have an investigation to happen here to get an interim temporary order, I don't have an objection to that. However, I'm pretty sure brother counsel and I can work out an interim order between now and July. But right now, that is correct. They kind of are operating on their own parenting time schedule.
Okay. I'll leave it to counsel. I mean, I'm just offering a suggestion. If we're obviously trying to keep down expenses and involvement, obviously Mr. Walker is available this morning if you need to talk with him for another 15, 20 minutes to fine tune this court starts with a position that the parties should share joint legal custody. So they share equally a major decision to the welfare of the child or children. And this court is not getting hung up on physical custody, simply legal custody and parenting time.
Your Honor, would it be possible to put Mr. Motley and I in a breakout room for a second?
Certainly. Do you want Mr. Walker or not? Just two of you?
Just the two of us right off right now, if you don't mind.
Yeah, we do that.
Okay, we can do that. We'll put the parties in a waiting room and counsel in a breakout room.
Thank you, Your Honor.
You are welcome. Counsel, be able to come to any closer toward an agreement?
Yes, Your Honor.
Yes.
I know I've spoken with my client. I believe Mr. Motley also has spoken with his client. We are in agreement on an interim order of joint legal custody. And the parenting time schedule will continue on an interim basis. It's a 2-2-5 schedule, Your Honor. And both parties, based on that schedule, have equal parenting time. There is one minor detail we're trying to work out, and it has to do with the right of first refusal and the details of that. And hopefully Mr. Motley and I, between now and July, can work that out with our clients. If not, we can proceed to mediation with Mr. Walker, and we can work on that.
And what time was the schedule? It's on 1:30 on the 24th of July. Is that correct?
Yes, Your Honor.
All right. So perhaps the court could take some brief testimony this morning from the parties. They can both verify their adherence to this agreement. They believe it to be in the best interest of their child. Work with everyone.
Yes, Your Honor.
Yes, Your Honor.
And at least by entering a temporary on the record, a temporary custody order this morning, it'll stop the court's clock. So I appreciate that, counsel. All right, Ms. Keister and Mr. Henning, can you both please raise your right hand? All right, Mr. Motley, if you want to begin with Ms. Keister, please, just to confirm with her understanding of this arrangement and her belief that's the best interest of my child at this point in time.
All right. All right, Ms. Did you hear the agreement placed on the record?
Yes.
You're understanding that you're agreeing to enter into an interim temporary order that awards both parties joint legal custody?
Yeah.
You understand that might include that pretty much any decisions relates to a medical decision, educational decision, religious upbringing, anything pertaining to that, that's going to be something that you and defendant father have a 50-50 decision-making power in, correct?
Yes.
And you believe at this point in time that that temporary while that temporary interim order would be in the best interest of your children?
Yes.
You understand that on an interim and temporary basis, you're entering into a parenting time schedule that's 2-2-5. And as I understand that, that's you having Monday, Tuesday, dad having Wednesday, Thursday, and the parties alternating weekends, or is it the other way around?
The other way around.
So dad, defendant father would be having Monday, Tuesday, you have Wednesday, Thursday, and you guys alternate weekends?
Yes.
And at this point in time, you believe that arrangement on a temporary and interim basis is in the best interest of the children?
Yes.
Your Honor, I don't have any further questions at this time. The only thing that I ask, and I don't think this is very different than what we put on the record, is that the matter of parenting time still be reserved.
Well, it's a temporary, according to understand, this is a temporary basis. We can revisit this when we come back on July 24th. Thank you, Mr. Malley. Mr. Ontropolis, do you have any questions, first of all, for Mrs. Keister?
No questions from Ms. Keister, Your Honor.
Questions for Mr. Henning, please.
Mr. Henning, you heard what was placed on the record, whereby you and Ms. Keister will have joint legal custody of your daughter.
Yes, sir.
And that the current schedule, which is a 2-2-5 schedule, will continue on an interim basis.
Yes, sir.
And you believe that that's in the best interest of your daughter?
Yes, sir.
Your Honor, I have no further questions.
Thank you. Mr. Malley, do you have any questions, Mr. Henning?
I have no questions for Mr. Henning, Your Honor.
Very well. I'll leave it to counsel as to whether or not you want to prepare a temporary order in that regard. Otherwise, it's noted for the record, and we can simply finalize things when we appear back on July 24th. The court finds the agreement of the parties, the parents, to be in the best interest of minor child. Obviously, the parents know what's best for their child, and so the court will adopt that agreement and mail out notice of a continued pretrial conference subsequent to the July 24th 1:30 mediation with Mr. Walker. And the court will provide you with Mr. Walker's Zoom ID number in that notice. The court would like to thank and acknowledge counsel for their efforts this morning. And the court would applaud you, Ms. Keister, Mr. Henning, for reaching your own agreement. Your child will flourish when you can work together for, of course, nowadays with the pleadings, we don't know if it's your son or daughter, but anybody, your 5-year-old child will do well when you're on the same page. So it's a great start, and I applaud you for that. And there will be bumps in the road in the future, but effective communication you can address those bumps. So there's enough challenges in life. Make it good for each other and your child. So I applaud you for reaching this agreement on a temporary basis, and hopefully you can continue to build upon those agreements in the future. Anything further this morning, counsel?
Your Honor, only that I'd like to thank you for your patience and understanding and guidance this morning. And I look forward with continuing to work with Mr. Motley to resolve this.
All right, absolutely.
I would echo that, Your Honor.
All right, you'll do some discovery in the meantime regarding income and so forth, so that we can come back and address child support. Of course, if you can't reach agreement, we can always refer to the front of the court for formal investigation recommendation. And will they all get copies of W-2s and recent pay stubs and so forth, and tax returns? But if perhaps council can work through that together.
Yep, I don't think that's going to be.
I'm confident we can.
Yep.
All right, great. All right, well, that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge. You do this.
The records matters before the court for parenting time review, as well as a continued pretrial conference. This hearing is being conducted via Zoom. Present is Attorney Matthew Motley, representing the plaintiff, Kristen Keister. Is it Keister or Keister?
Keister.
Keister, right? Ms. Keister is present. In addition, Attorney Ontropolis.
That's correct, Your Honor.
Good afternoon. I want to make sure right. So Ontropolis is present, representing the defendant, Father Dwayne Henning, and Mr. Henning is present.
Yes, sir.
The court has been informed that with Mr. Walker's assistance, the parties reached partial agreements. Is that correct?
Yes, Your Honor.
Okay. Who would like to place that agreement on the record?
I wrote down all the terms, so if brother counsel here is okay, I can at least get a stab at it.
Sure.
Please, Mr. Molly.
All right. So as I understand it, the parties have agreed on having joint legal custody. This order will be silent as to physical custody, as that will be determined at a further hearing. For tax benefits, plaintiff will be claiming the minor child on even tax years, and defendant will be claiming the minor child on odd tax years. And then parenting time, depending on which school this court determines the child will be going to. The custodial parent will have weekdays from Monday through Friday, and the non-custodial parent will have 3 weekends a month with a few hours in the middle of the week, maybe 2 to 3 hours on a Wednesday visit. And then obviously the the custodial parent has 1 weekend a month. And then that schedule will be flip-flopped for the child's summer break.
Very well, thank you. Mr. Ontropolis, is that a correct statement of your client's agreement?
It is a correct statement, Your Honor. However, I didn't have the opportunity. It didn't dawn on me at the time we had Mr. Walker with us. In the month where there's 5 weekends a month, I don't know how we're going to address that.
I've previously done it as weekends 1, 2, and 4 for the 3 weekend, and then you just define it as a weekend where the Friday has to be, if it's going to be the first of the month, it's got to be on a Friday. But I guess so it'd be one, so that would be the 1st, the 15th, and the 22nd. So I guess we might have a 5 weekend problem.
Do you want to discuss the matter further with Mr. Walker this afternoon?
Yeah, I just think that would make sense if we could just maybe have a little bit more time to address that.
Okay, and counsel, I will tell you, first of all, this court does not get hung up on physical custody. As this court's opinion, the issues are legal custody and parenting time.
Correct.
And I know it, and Your Honor, I totally appreciate that. I know it's kind of a dying term because it just tells us a number of overnights, but the primary custody is going to be hinged. I hate to say that because I know it's not a term this court uses, but it's riding on which school this child's going to be going to because the parties live approximately 30 miles apart.
There's no petition before this court to determine school district. So that's new to me. That's an issue just now. I think before the court schedules evidentiary, we need a petition. Who's petitioning? And how old is the child?
Child is 6.
Okay. So
And the
he's
child,
entering what, the first grade?
Yes.
Yes.
Was that discussed this afternoon?
Yeah, this is just an agreement the parties are placing now.
It
I guess we'll have
was,
to work out the schooling. I don't know if we can accommodate a hearing in the next 3 weeks. And first of all, I need a petition from one or the other, or both. If they're both complaining different school districts, we need to have some pleadings filed before we can schedule an evidentiary hearing.
I mean, we could
We'll take one step
submit
at a
the same.
time.
I mean, I figured that might be contemplated in the underlying complaint for custody, where I know physical custody is not the term they are looking for, but we're asking that the child primarily reside with the plaintiff. So I figured that would be contemplated. And obviously where the child goes to school is obviously a basic tenet of joint legal custody, where the parties otherwise are agreed to having joint legal custody. Where the child goes to school is that issue, but I could submit a motion.
Right. And if the parties have joint legal custody, if they cannot agree, then they have a stranger decide where their child's going to go to school, and the court will do that. I don't know if we can accommodate that between now and in the next 3 weeks, because school starts the last week of August. Is that correct?
Yes, after Labor Day.
Have these parents not discussed the future of their child before today?
We have.
No,
Sorry.
I would say, yeah, they have discussed it. Obviously, they've reached an impasse. If you're saying maybe another mediation session might do it, I'm sure the parties would entertain that. But obviously, this is not the first time they've discussed which school,
Right.
and that
Right,
may
well,
have been the reason for underlying complaint.
Okay,
I'm sorry,
the primary issue
if I
is
can
parenting time. Let's get that clarified this afternoon about this 5th week of the month, if need be. Talk to Mr. Walker, then come back out, and I can look at some calendar, some dates for school determination, but I want the motions filed in the interim, so that's properly before this court. The court has a trial briefs from each side in terms of what they're proposing. So I'll have a talk to Mr. Walker. Let's nail down this main issue of parenting time, please.
Thank you, Your Honor.
Parties and council conferred further regarding parenting time in the event there's a fifth week of every month. Mr. Motley, have you been able to reach agreement on that last issue?
Yes, Your Honor.
Okay. And what is the agreement?
Is that the fifth weekend would be going to the party that doesn't have that primary custody arrangement?
Okay, but we don't have a primary custody parent right now.
Your Honor, if I may, so we just had a conversation with Mr. Walker. Currently before the court, when we last appeared, there's an order with the court that the parties have joint legal custody with a 2-2-5 parenting time schedule.
Correct.
That will continue until we can schedule an evidentiary hearing, hold that evidentiary hearing for a further determination whether the child's going to remain in Summerfield School District or will change school districts. So that's where we are right now.
And the court did note in the pleadings, defendant's pleadings, that the child is enrolled in Peters or Summerfield School District. Is that correct? Went to kindergarten in Summerfield?
Correct.
Yes.
That's how I understand it.
Is the child currently then enrolled in the first grade?
Yes.
Okay, but mom resides in
Monroe.
a different community. Where does mom reside, Mr. Molly?
Monroe.
Oh, okay. I thought so. They live relatively close. It's so if the child's in Summerfield, then I guess mom would have to. She's petitioning that the child be transferred to Monroe Public Schools.
Jefferson.
Well, but, mom doesn't live in Jefferson School District, so I don't know how that's going to happen.
Yeah, it's Jefferson School District.
Oh, okay. So you live in Monroe County, but within the Jefferson School District.
Yes.
Okay. Has the child also been enrolled in Jefferson?
Not yet. I've been waiting for this
Okay.
till we figured it out.
Again, there was no request. The court was certainly caught off guard by it. All of a sudden, well, we can't agree upon school. I was not informed of that when the parties appeared to back on and put the original agreement on the record back on June 6, 2024. I've got two dates. Council, can we do this in half a day?
Half a day, I would guess, would be sufficient.
Okay, a week
At
from
least.
Monday, August 5th, 8:30, in person.
You're saying the evidentiary hearing would be?
Correct. I mean, we're
Okay.
talking about 3 weeks before school's gonna start the last week of August.
No. I
Is that
understand. Just
date?
let me double check my
I've got
calendar.
a day full of pre-trials, so there'll be interruptions, but I can do that at 8:30 that morning.
Your Honor,
The other option is the afternoon of August 15th. Two
the
dates
afternoon of
before
August, the afternoon of August 15th works for me. The August 5th does not work for with me.
15th would be better for me, too.
All right, August 15th, 1:30 in person. The court's gonna request that the parties exchange. And first of all, we need some motions. So both of you should file a motion. I guess actually it appears that the mother should be the one filing the motion. She wants to change the school district from Summerfield to Jefferson. So
We'll
Ms.
submit a
Molly,
motion.
you should file the motion. And the court would require that the parties exchange witness exhibit lists as well as trial briefs on or before August 5th.
All right.
And I'll put that in a notice. It'll be an in-person
That'll be in
hearing.
the
The
afternoon,
child
Your
is
Honor.
too young to express a preference.
I'm sorry, Your Honor, you broke up on me. I'm sorry. What was the last part?
For the purpose of interviewing the minor child, would the parties agree that the child is too young to express a preference as to schooling?
Yeah.
I'm asking counsel.
Yep.
Counsel,
I
Yeah,
would
would
you
yes, Your
agree? Hold on, ma'am, just please, can you mute the parties, please? Counsel, would you agree that the child is too young to express a preference as to school preference, or should the court interview that child?
I would agree, Your Honor.
That child is too young, correct.
All right, thank you. All right, you can unmute the parties. All right, so the court will not interview the minor child. With respect to who's got is there a joint established custodial environment to the parties that both have an established custodial environment with the minor child? That's a critical decision that needs to be applied.
Yeah, that might be where the parties disagree, and hence the underlying request in the complaint.
Okay. Well, who spent more time with the child in the past 5 years?
Your Honor, I
Plaintiff
believe.
said it was plaintiff.
Well, I think we would disagree with that, Your Honor. I think that both parties have an established custodial environment. They've been operating on a 50-50 parenting time schedule. The child's been enrolled in Summerfield School District. I would argue that at the very least, both of them have an established custodial environment.
Have the parties been sharing relatively equal parenting time for the past 3 or 4 years?
No, but for maybe the past year and a half.
Mr. Henning, I believe it's been longer than that. Is that correct?
Yes.
Well, it would appear then that without hearing the testimony, it would appear to the court that the parties have an established custodial environment. The child has an established custodial environment with each parent, which means that any school district decision would not modify custody, and that the mother would have the burden by preponderance to show that's the best interest of the minor child to change the school district. If the child attended kindergarten at Petersburg, it would appear, and I'll listen to further argument, it appears that mother would have the burden to prove by preponderance that best interest of the child be served by switching schools from Summerfield to Jefferson. So, council, again, obviously, please follow a motion, Mr. Motley, requesting a change of the school district. If the child did attend Petersburg, most recently, but that was only kindergarten, and the court will look forward to the briefs by the council, but we'll set this for an in-person after hearing August 15th, 1:30 p.m.
Thank you, Your Honor.
And who will prepare the order regarding today's agreement?
Your Honor, Mr. Motley prepared the previous one. I'll prepare today's order.
Was there? I did not see a prior order. Simply put, I had.
We had it submitted in the mail, Judge. You should get it any day.
All right. So I just have notes from agreement. So council will prepare. Mr. Motley will prepare the prior order. Is that correct?
Yes, and that should be in your hands any day. Now, we already submitted it via mail, maybe about a week or so ago.
Very well. And Mr. Ontropolis will prepare the agreement reached today. That order, is that correct?
That's correct, Your Honor.
All right. All right. We'll see everyone then on the afternoon of August 15th, 1:30 p.m.
Thank you.
Thank you, Your Honor.
Welcome. For the record, this matter is before the court for continued pretrial conference. Subsequent parties have engaged in mediation with Ms. Patrick from the front of the court this morning. Present is Attorney Maria Zagorski, representing the plaintiff, Veronica Enyboik. Is your client present within your office, Ms. Zagorski?
Yes, she's right here across the desk from me. Say hi.
Thank you.
Hello.
Thank you.
You're
In
welcome.
addition, an attorney who probably is present representing the defendant, Shima Enyboik. Good morning, everyone.
Good morning.
The court has been informed the parties have not made much progress this morning. Is that correct?
No, I don't think that that's a fair statement, Judge. We made a lot of progress. We got very, very close. Things fell apart when we started talking about attorney fees, but we otherwise had the case settled.
Well, the parties are going to spend more in the amount of attorney fees being argued about if we're going to litigate and try this case.
Agreed.
I'm sorry. The parties have exhausted all efforts this morning. Is that correct?
Yes, Your Honor, we did our best to get this case settled, and I think we got to a settlement until the plaintiff started talking about attorney fees, and that's where we objected, and we're not going to pay any attorney fees. And my client's ready to go the whole 9 years to make sure this case is tried if they insist on attorney fees. Otherwise, we are still open for them to the agreement we had before the issue of attorney fees crept up. We're still open to that, but if they refuse that and they want to insist on attorney fees, we are ready to try this case because by the way, Your Honor, the truth of the matter is the plaintiff didn't even disclose what you asked us, what you ordered us to disclose. We did our own disclosures, the interrogatories we filed, they didn't answer, we answered theirs. We did everything we were supposed to do. They never did anything. I never got anything from them. And yet we still went ahead to talk about settling this matter. And yet they're talking about attorney fees. So they make us look like we don't know what we're doing.
We put on the record the agreement the parties have reached thus far, and you can reserve the issue of attorney fees, and the court can address that separately. Is that acceptable? When we have a short-term 5-year marriage, we'll look at the income of the parties. I mean, generally, each party should pay their own attorney fees, unless there's a significant disparity in income.
We think that she has a lot more in assets. We have let go of
a lot of stuff. We were not interested in marital assets, whatever they have, the car, the house, household items, everything.
We're not going to litigate this right now. Can we put a partial agreement upon the record? Have we resolved issues of retirement benefits, spousal support, those kind of important issues?
We have some of that, Judge. Quite frankly, this is a very difficult situation for my client. She's had a lot of events in her life, and she's gone. I think she's just exhausted, and we've gone as far as we can go today. I would like to come back to the table to finish this up, take the proofs today, sit down with Ms. Patrick after everybody's had a chance to breathe for a minute. We've been going at it for more than 2 hours, and I think it's salvageable. We just need to step away.
All right, that makes sense, Ms. Gorski. That makes sense.
In response to that, if this case is not settled today, we
are ready to try this case, Your Honor.
All right, well, good luck in the trial date, sir. Again, the court, Mr. Gorski indicates that there's still a possibility that we've made significant progress, that people need to take a breather, and then that's certainly understandable. So what the court would suggest, let's take the proofs today. We'll stop the court's clock. I'll reserve all outstanding issues. And Ms. Patrick, do you have another date for continuing mediation sometime later this month? I know one time you had a date of the 27th of June available. Yeah. Is that still available?
It is still available, Your Honor, and that would be my first availability would be June 27th. I could do it in the afternoon at 1:30, or I could do it in the morning at 9.
I would need the morning. I'm with Ms. LaPlante.
Ms. Zagorski indicates she needs the 9 because she's already in mediation with one of the other facilitators.
Right, Mr. Wabi, the court would like to one final effort of the parties to discuss and reach your own resolution. Are you available at 9 o'clock? You and your client on June 27th, which is the last Thursday of this month. It's actually 3 weeks from today. And things will be fresh in everyone's mind, but it still gives some time for breathing. I'm sorry, sir?
Yeah, June 27th, 9 o'clock in the morning.
We'll be available, Your Honor.
All right. Well, the court will mail out notice that the parties shall mediate with one final time with Ms. Patrick on June 27th at 9 a.m. And then subsequently appear before the court for a final pretrial conference. If we can now resolve the matter at that time, the court would then most likely schedule a trial date. But it's a 5-year marriage. The court believes this matter should not to be resolved. In any event, the court would like to take the proofs today.
I am prepared to do that, Judge.
Court will reserve all outstanding issues. Mr. and Mrs. On your bike, can you both please raise your right hand to be sworn, please? Thank you. Mrs. Zagorski, you're going to begin with your client, please.
Yes, thank you, Judge. Would you please state your name for the record?
My name is Veronica Johnson Anya Boyke.
And do you remember signing a complaint for divorce on February 29th of this year?
Yes, ma'am.
At the time that you signed the complaint, had you been a resident of the County of Monroe and the state of Michigan for 180 days?
Yes.
Did you and your husband have any children during your marriage?
No children we have.
Did you adopt any children?
I think I did. Oh, well, I don't know. His children. I got his children here, so I think they're my children.
They're your stepchildren?
They're my stepchildren.
Okay.
I sent for them from Nigeria.
Okay. And are you pregnant?
No, I'm not pregnant.
Okay. And is it true that there has been a breakdown in your marriage relationship?
Yes, ma'am.
Have the objects of matrimony been destroyed?
Yes,
Is there any likelihood whatsoever that this marriage can be preserved?
I wish, but no.
Okay. Thank you.
You're welcome.
That's all I have, Judge.
Ms. Gorski, it was unclear to the court. Did she adopt any children during the marriage?
She did not. She considers her stepchildren to be her children, but she did not formally adopt them.
All right, thank you.
I signed documents for them. I thought that was it. I
All right,
signed documents.
Mr. Bobby, do you have any questions of the plaintiff?
Yeah, the question I had was,
What you asked about adoption, we wanted to make it clear that there was not adoption. It was just, living together.
Understood. Any other
They were not-
questions?
The kids were not adopted, Your Honor.
Really?
That was the question I wanted to ask.
Okay. All right, if you can just confirm with your client, Mr. Chima, that he's heard the testimony of his wife and that testimony is true and accurate to the best of his knowledge, please.
I'm going to start from the beginning. Mr. Anyabike, state your name for the record, please.
My name is Chima Emmanuel Anyabike.
And when did you start living in Michigan? Is it over 180 days?
Correct. It is.
So do you know that woman that appeared before? Were you married to her?
Yeah, she's my wife.
Do you have any kids with her?
No kids.
So do you think that this marriage can be salvaged in any way, shape, or form?
The marriage has failed.
So there is no way that this marriage can be restored.
Yes.
I rest my case, Your Honor, on this.
Right. Ms. Gorski, do you have any questions of Mr. Chima?
I do not. Thank you, Judge.
Earl, based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reason likely that the marriage can be preserved. At this point in time, the court will reserve all standing issues, or that the parties can make one final effort to mediate with Ms. Patrick on June 27th, 2024, 9 a.m. and subsequently appear before this court for a final pretrial conference. The court will mail out notice.
thank you, Your Honor.
You're welcome. That concludes my effort. Can zoom out. Have a good rest of the day.
Thank you.
You're welcome.
Versus Chima Anyabike.
Good morning, Your
This
Honor.
matter is before the court for a continued pretrial conference subsequent to continued mediation with Ms. Patrick from the front of the court this morning. The present is Attorney Maria Zagorski representing the plaintiff, Veronica Johnson, Anya Buke. Ms. Anya Buke is also present with Ms. Zagorski. In addition, Attorney Pascal Ukpabi is also present representing the defendant, Chima Anyabike. Anya Buke, is that how it's pronounced? Anya Buke?
Anyabike.
Anya Buke.
Correct.
Thank you. Good morning. The court's recollection was when the parties last appeared, we met with Ms. Patrick, we took the proofs, and the court was informed that the only issue was the plaintiff's request for attorney fees. Is that still the only issue?
No, Your Honor.
Yeah.
I'm not quite sure how to present this to you. My client tells me that she did not take her vows lightly, was committed to the marriage, and still wants the marriage to work. It's my understanding that Mr. Anyabike does not, but she would like to continue to fight for her marriage.
Yeah, in response to
Someone
that,
that filed for the complaint for divorce, that she wanted to dismiss her complaint.
She does.
Okay. Has a counter complaint for divorce been filed?
No.
from my
Client's perspective, he's not interested in continuing with the marriage because of what has happened during the course of the marriage, the various times that his life has been threatened, the so many threats to his life, a felony conviction that he was not apprised of before the marriage, which is public record, that cannot be denied. A lot of other issues that my client cannot deal with, going to his job with a shovel to try to harm him, and all that. These
Okay,
are facts.
sir, Mr. Bobby, there's no purpose served in rehashing what's happened in the past. The question
Okay,
is, your
yeah,
client
I'm
wants to
sorry.
proceed with.
I'm sorry, Anna.
Your client's
I'm sorry.
your client is unwilling to stipulate to a dismissal. Is that correct?
I'm willing to stipulate, Your Honor. I'm willing.
Okay. You need to file a counter complaint for divorce.
Yeah, she filed a complaint. I mean, she has not withdrawn it, so we are ready to go the whole 9 years to get a divorce. If she withdraws it, then we know what to do,
Ms.
sir.
Zagorski, counsel, correct me if I'm wrong, because the court needs a stipulated order of dismissal. Is that correct?
Well, yes, I believe so because an answer was filed, but she does wish to dismiss her complaint. She does.
Right, but can the court do that without a stipulation?
I don't believe so. My
Okay.
client would be responsible for his attorney fees and she doesn't want to pay those. So I'm kind of stuck.
I want my marriage.
She wants her marriage to work.
All right. All right. So the court must have to move this if the Mr. Anya Boyke wishes to proceed with this. I guess all we can do is set it for trial then.
Okay.
Yes, Your Honor.
Okay. But the parties cannot. All right. Again, obviously, Ms. Gorski, you tell your client if we proceed to trial, the court's going to grant the divorce if that's what he wants.
Understood.
Mr. Akbubi, you should file a counter complaint for divorce. To properly put the order, file an order, you should file a counter complaint for divorce.
Yeah.
Can you do that
Yes,
within
after
14 days?
That's after she withdraws. That is if she withdraws her complaint or file a counter complaint for divorce.
Yes. Can you do that in 14 days? File a counter complaint for divorce?
Yes, Your Honor, we can do that, Your Honor.
Okay. All right. The court will order that the defendant file a counter complaint for divorce within 14 days of today's date. So we're just going to go through the motions end of a trial. Are there any agreements on anything? Property?
There's no real property, so that's not an issue.
As the parties are separated, correct?
Yes, that's correct.
Is there personal property to be divided?
No, I think Mr. Anya Buike took everything he wanted when he left.
Okay. So what are the issues?
The funds expended during the marriage, my client's position, Your Honor, is that this marriage was entered into fraudulently, and we will present evidence that shows that Mr. Anya Buike, it's effectively fraud in the inducement, and that my client expended significant amounts of money to ensure his ability to reside in the United States and to maintain the marriage. So I guess it would be reimbursement, for lack of a better word.
Yeah, now in response to that, this is all not part of a divorce. There's no fraudulent divorce entered into. In fact, if there was a divorce, it was from plaintiff who did not disclose her criminal records before the marriage was entered into. We will, plead all those in a kind of complaint, and we'll go from there. This is public record. But in terms of entering a marriage fraudulently, my client denies it, and we're gonna do that in our kind of complaint.
I don't have a criminal record.
I know.
Okay.
So it's very.
Okay.
All right. I guess the court doesn't know what to do other than move this matter forward to a trial. Again, the court will order that the defendant file a counter complaint for divorce within 14 days of today's date. And if you have your calendars, we have some trial dates available in August. How about August 8th at 8:30? It'll be an in-person trial.
That's fine.
Let's see. August.
It's a Thursday, August 8th.
August is the Thursday, Your Honor. We are available.
Okay. All right. The court may notice that the party shall appear personally, be an in-person trial, August 8th, 8:30 a.m. The court will again order that the defendant file a counter complaint for divorce within 14 days. And further, that the parties present to the court a trial brief on or before August 2nd, Friday before. a brief trial brief setting forth the issues and their respective positions on or before the Friday, August 2nd, the week before.
Okay, will do.
And one more thing, I will also part of our complaint, we will also probably add a motion so that plaintiff can answer our interrogatories according to the court rules, which we have demanded, but which has not been done. Court rules does not, does not recognize answering complaints on email, which I advised Sister Counsel here that I need them according to the court rules. She promised to do that, but she has not.
I did do that, sir. I have a proof of service right here. On June 6th, they were mailed to you. Both the domestic
June
relations.
6th? Okay.
Excuse
That's
me,
fine.
the domestic relations verified financial and my client's answers to interrogatories. They were all sent to you.
Okay,
Nope.
I've not received them. That's what I'm saying. Maybe
Don't believe I have your client's domestic relations verified financial information form.
yeah. Excuse me, what did you say?
I do not believe that I've ever received your client's domestic relations verified financial information form.
Well, it was part of the answer we did. We sent it to you. You don't have it?
I have your client's answers to interrogatories, but I do not have his domestic relations verified financial information form.
Okay, I'll have to look into my file to see what we can do. But if everything that was sent to me was responded to, so I'm not gonna say here that you're lying or anything, but I have to
No,
look at my
I
file.
didn't serve you with a domestic relations verified financial information form. You have to provide that. I don't have to serve it on you.
Do you have to supply yours to me?
Yes, and I did,
Okay, I have not received it, so we're on equal terms.
but you haven't supplied yours to me.
That's what I'm saying. So, I mean, if I look into my file, if we have not received it, I will do that.
Thank you.
Thank
All
you
right,
very
the
much.
court will order that the defendant file and serve his counterclaim for divorce as well as his verified financial information form upon the plaintiff within 14 days of today's date.
I have a quick request. I need him to stop calling me.
In order to that effect, Ms. Corsi, I'm going to prepare an order to that effect.
Yes, I will.
And the court will mail out notice, again, a in-person trial, August 8th, 8:30 a.m. Trial briefs due on or before August 2nd to 2024. Anything further this morning?
Judge, I can put all of that in the order. If you don't, to avoid you having to send out a notice, I can put all of that in the same order.
I'm going to still send out a trial notice.
Okay.
Okay. Thank you, Your Honor.
If you can, I guess we do need an order regarding the filing of the counter complaint as well as the verified financial information form.
Yes, I will do that.
You got that. All right. Hopefully the parties can work through their differences. Obviously, if one side wants to make it work, short-term marriage, maybe they can communicate and work together and put past differences behind them and move forward.
We'll keep you posted, Judge. If they reconcile, we'll let you know.
Okay.
Thank you.
All right, thank you,
I'll
Your Honor.
conclude this. Everyone can zoom out. Have a good rest of the day.
All right, thank you, Your Honor.
Mr.
Thank
Runkle,
you.
if you have a hat on, can you remove it, please? Thank you.
Yes. For the record, this matter is before the court for actually pre-trial conference scheduled for tomorrow, but the parties engaged in mediation with Ms. LaPrade for the front of the court this morning. This pre-trial conference is being conducted via Zoom. President Attorney Kirsten Nemec, representing the plaintiff Judy Duderstadt. Mr. Duderstadt is present. In addition, Attorney Kimberly Kuhn is present, representing the defendant. Donovan Runkle and Mr. Runkle is present. Good morning, everyone.
Good morning, Your Honor.
We have a 7-year marriage. Are the parties able to make any progress this morning, Ms. Nemec, Ms. Kuhn?
Yes, Your Honor, we have a full agreement.
Wonderful. Who would like to place an agreement on the record?
I can do that, Your Honor.
Please, Ms. Nemec.
So the parties have a marital home, which is awarded to Mr. Runkle. There will be no equity paid to Ms. Duderstadt for her interest in that property. Ms. Duderstadt will be able to remain in the home for the next 90 days. While she is in the home, she will pay the DTE bill But Mr. Runkle will be responsible for all other expenses related to that home. In consideration of the fact that Ms. Duderstadt has paid his car insurance for the next 6 months and is not seeking reimbursement for the same. With regard to personal property, Mr. Runkle is awarded the 2015 Ford F-150 and the 1993 boat. I don't remember its make and model, but there's only one boat. So he gets the boat. Ms. Duderstadt will be awarded the 2014 Ford Taurus. Each party is responsible for all costs, fees, and liabilities associated with the items of property that they're awarded, and will hold the other party not liable. Sorry. As far as personal property goes, each party is awarded their own premarital personal property. And there has also been a list that was passed back and forth with regard to personal property. So there are some understandings there as well. But the personal property will be divided by agreement. If there is any disagreement, the parties agree to engage in binding arbitration with Mr. Godfroy. Each would be responsible for half of the costs of that arbitration should it be necessary. And that arbitration would need to be requested within 30 days of Ms. Duderstadt vacating the marital home. Otherwise, if it's not requested, each party will be entitled to keep whatever personal property is currently in their own possession. With regard to bank accounts, each party is entitled to the bank account in their own name. There are no joint bank accounts. Each party is entitled to the entirety of the retirement account in their own name, investment accounts in their own name as well, and each party is responsible for the debt in their own name. Ms. Duderstadt will be keeping or retaining the ownership interest in Midwest Veterinary Partnership. She free and clear of any right, claim, or interest of Mr. Runkle. Mr. Runkle will receive back Ms. Duderstadt's engagement ring in exchange for the party's dogs. Ms. Duderstadt is entitled to possession and ownership of the dogs. No spousal support is awarded to either party, and the same is forever barred. And finally, Mr. Runkle will immediately release Ms. Duderstadt's cell phone number so that she can establish her own cellular phone account with that same number. And I believe that's the entirety of the agreement.
Thank you, Ms. Nimick. Ms. Kuhn, did Ms. Nimick accurately state your client's agreement?
Just a couple of things. If the parties have any life insurance policies, they would also be awarded their own. I'm just trying to clean up just some of the provisions. Ms. Nimick did an excellent job though. With regard to the engagement ring, it's actually a wedding and engagement ring. It's a set. So he would receive that wedding and engagement ring back. And is there a date that we can put down that he can expect to get those back?
Well, I would think as they're exchanging personal property, once they've finalized that, that's when I think she could turn over the engagement rings. Or
but if she's going to take the dogs, it was the dogs for the engagement and wedding rings. So can we say that at the point in time that she's vacating with the dogs, he will at least have the engagement and wedding ring at that time?
Yes, that's fine.
Okay, very good. And they each pay their own attorney fees. They're also each responsible for their own insurance and any medical bills that would result. Your Honor, with regard to the vehicle insurance, that bill is in the plaintiff's name. It was paid until October. So my client's not going to have to pay her any money towards being having that insurance through October, but he's also going to be insured through that date. So those are the only, I just want to make sure. There's no deed required for the house either, Your Honor. It's just in my client's name. And I don't believe there's anything else, correct? I think that covers it. Okay, I think we're covered. Thank you, Your Honor.
Right, thank you, Ms. Kuhn. Ms. Nimick, were those clarifications acceptable?
Yes, they were. Thank you.
Very well. Ms. Duderstadt, Mr. Runkle, can you both please raise your right hand to be sworn? Ms. Nimick, you can begin with Ms. Duderstadt, please.
Okay. Judy, could you state your name for the record?
Judy Duderstadt.
Okay, and you are the plaintiff in this action for divorce, correct?
Correct.
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days and also in the county of Monroe for at least 10 days?
Yes.
There were no children born of this marriage, correct?
Correct.
And you're not currently pregnant, right?
Correct.
Okay. And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no likelihood the marriage can be preserved?
Correct.
You heard the agreement as I placed it on the record and the clarifications that Ms. Kuhn placed on the record?
Correct.
Did you understand all of it?
Yes.
Did it reflect accurately the agreement you believe that you're entering into?
Yes.
You have any, oh, I asked you questions. Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Do you understand that you could have taken these issues to trial and asked the court to make a decision, and then that the court's decision could have been different than the agreement that you reached today?
Yes.
But rather than do that, you're asking the court to adopt the agreement that we just read into the record and make it a judgment of divorce.
Yes.
Have you disclosed all of your assets and liabilities to Mr. Uncle?
Yes.
Are you satisfied with my representation?
Yes.
I have nothing further, Your Honor.
Thank you, Ms. Nemick. Ms. Kuhn, do you have any questions, first of all, for Ms. Duderstadt?
I do not, Your Honor. Thank you.
Questions for Mr. Runkle, please.
I do. Thank you. Donovan, can you state your full name?
Donovan Ashbrook Runkle.
Donovan, you heard the agreement that was read on the record?
Yes.
Do you understand all the terms and conditions of that agreement?
Yes.
Is it true that you and I have had an opportunity to discuss all the issues that make up this agreement prior to mediation?
Yes.
And do you have any questions with regard to any of the terms and conditions of this agreement of either myself or of the court?
I do not.
Are you representing to the court that this is your agreement today?
I am.
And you understand, Donovan, that had we gone to a final hearing in this matter, the result could have been better, it could have been worse, or the same.
Correct.
And notwithstanding that fact, you're asking the court to adopt this agreement and make it an order of the court, correct?
Correct.
Has anyone threatened you, induced you, or forced you into entering into this agreement?
No.
You're doing this of your own free will.
Yes.
And you understand that with regard to spousal support has been forever barred as to both parties. That means you and your wife are waiving your statutory right to ever petition the court for an award of spousal support. You understand that, correct?
I do.
Are you satisfied with my advice and counsel?
I am.
Have you made a full disclosure of all your assets and liabilities in this case? No further questions.
Thank you, Ms. Kuhn. Ms. Nemick, do you have any questions of Mr. Runkle?
I do not. Thank you.
You'll prepare the judgment, Ms. Nemick?
Yes, I will.
Well, the court would like to thank and acknowledge Ms. LaPrade for her assistance in helping facilitate resolution, as well as, of course, attorneys Nemick and Kuhn for helping the parties reach their own agreement. And the court would applaud you, Mr. Runkle, and Ms. Duderstadt for reaching your own agreement. It's without question the best resolution, rather than this court decide these matters. Keep in mind, you will not be divorced till the court signs written judgment. Hopefully that will be in the next couple of weeks. With this agreement, of course, the court will vacate and cancel the pretrial conference scheduled for tomorrow morning at 11 o'clock. Thank you, Ms. Nemick and Ms. Kuhn, for being proactive and moving these matters forward and scheduling mediations at that's good with your respective schedules. Based on the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. According upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Ms. Kuhn and Ms. Nemick. That will conclude this matter. You can everyone zoom out and have a good rest of the day.
Thank you, Your Honor. You too.
Thank you, sir.
I got Asher's T-ball pictures here.
Good.
For the record, this matter is before the court for entry of a proposed consent judgment of divorce. This hearing is being conducted via Zoom. Attorney Kirsten Nemec is present, representing the plaintiff Leah Frank. Ms. Frank is present, as is the defendant Anthony Frank. Good afternoon, everyone.
Good afternoon, Your Honor.
Afternoon.
Parties were before the court on May 31st for a pretrial conference, as well as enter this judgment. The court had a conversation about the waiver of the 6-month statutory waiting period. Ms. Frank indicated there was no chance of reconciliation, and she was asking the court to do so. She stated it was in the best interest of the children to finalize things sooner than later. Mr. Frank was hesitant, and which the court could still have granted, but Mr. Frank seemed to suggest he was being rushed into enter this judgment. So the court adjourned the matter to July 19th, so Mr. Frank could talk to an attorney. My understanding is Mr. Frank has joined this request to have a matter brought before the court this afternoon. Is that correct, Mr. Frank?
Yes.
Okay. Have you had a chance to talk to an attorney?
I'm on the Asher. No. No, I didn't need to. I'm settled with the matter.
Okay. So what do you want the court to do this afternoon?
We're going to proceed and finalize this.
Okay. So let's pick up where we left off. There's a statutory 6-month waiting period. It's 6 months begins to run the date that the divorce complaint was filed. The divorce complaint was filed by Leah on February 20th. So it expires August 20th. This court has the authority to shorten that and waive that. And generally, it's in the best interest of the parties and children to move forward, unless you really think there's a chance of reconciliation, or there's a reason like Ms. Frank needs the health insurance through your employer and has a medical procedure coming up. So Ms. Frank is requesting the court, rather than sit on this till August 20th, she's asked the court to enter the judgment of divorce without delay. Are you today asking the same thing?
I am.
Mr. Frank, let me ask, obviously Ms. Frank is still asking the same. Mr. Frank, are you asking the court to waive the balance of waiting period and enter the judgment of divorce today?
I'm agreeing to it. Yes.
Okay. Again, you seem to suggest you're being rushed into things. You've had now another week to review this judgment, all the terms and conditions. If you not finalize things, if you want to change your mind, you can change your mind today and say, I want to renegotiate some of these terms. You understand?
No, I'm okay. I'm agreeing with it. I'm not the one that needs to push it till right now. I could have waited till August, but I'm agreeing with it for Leah's benefit. I'm good with it.
So you believe there's some value in simply finalizing things so you can move on with your life?
Yes, I understand that. Yep.
All right. Again, this court is of the opinion that perhaps Mr. Frank is holding out hope for reconciliation. Ms. Frank was pretty adamant that there was no chance for reconciliation. The court is of the opinion that most generally, unless there's a more valid reason, that the parties are the children are best served by finalizing things sooner than later. As a court recall, we did take all the proofs, the court established jurisdiction and everything. Is that correct, Ms. Nemec?
It is. And in addition, if it helps the court with regard to waiver of the waiting period, Ms. Frank does have an active PPO against Mr. Frank currently. And there was a domestic violence charge that was adjudicated in February, for which Ms. Frank was the victim. This is another reason.
That matter. Is Mr. Frank on probation?
No.
Okay.
It's really irrelevant. She just wanted to bring it up.
Okay. Is that still pending?
No, it was adjudicated in February. I'm not aware of what the sentence was, but it was a domestic violence charge, originally charged as a domestic violence second offense, was pled down to a domestic violence first. Mr. Frank was the defendant. Ms. Frank was the victim.
Okay. So
which has no bearing. Which has zero. Frank? It has zero bearing on whether we wait till now to August, but she just wanted to bring that up. Maybe she'll post it on TikTok again.
Well, is that PPO still in full force and effect?
It is, Your Honor.
Okay. And that's a separate issue from this judgment of divorce. I understand that, Mr. Frank.
I understand it. That's why I don't know why she's bringing it up.
Okay. All right.
You probably, but she just decided she needed to.
Well, people should get off social media. There's more problems caused by social media and TikTok and all that other garbage.
I don't have that. I was made aware of it.
All right, so Mr. Frank, do you have any questions for the court?
No.
Once again, do you want to talk to an attorney?
No.
And you have no objection to the court signing this judgment of divorce today, is that correct?
No.
All right. Ms. Nemec, is there anything further from your client's standpoint?
No, nothing further. Thank you.
The problem, the reason, Mr. Frank, Ms. Nemec probably raised that issue is because of the fact it gives you perhaps more reason why the parties should finalize things and move on with their lives. So no one's playing games here, trying to cast you in a bad light on social media. Hopefully there's no need for anyone posting this on social media. It's all matter of public record. In any event, based upon the testimony that was provided back on May 31st, 2024, as well as the complaint filed in this case, the court finds again that jurisdiction's been established. And the court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There's no reasonable chance of reconciliation. The court will, in fact, act without delay and waive the balance of 6-month waiting period. Enter the judgment of divorce today. According to order by this court that the marriage between the parties be and is thereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court will sign the judgment. Ms. Nemec will mail you a copy of this judgment for your records, Mr. Frank. And with this action today, the court will cancel and vacate the pretrial conference scheduled for July 19th at 9 o'clock. No need for that, okay?
Yeah. When did the actual payment arrangements and things go into effect? So July 1st then, or when would that?
August 1st. The Uniform Strasbourg order says August 1st.
Okay.
Is that correct, Ms. Nemec?
I believe so. I don't recall off the top of my head. I know that we had a uniform spousal support order and a uniform child support order. My recollection is that child support is actually reserved for the first year because in lieu of child support, he was going to pay non-modifiable spousal support in an amount around $3,500. And then child support would commence August 1st of next year when the spousal support would then modify. He would then be paying child support in the amount of $1,100 and spousal support in the amount of $1,100 for the next 18 months.
Yeah, that's all agreeable. From now till August 1st, though, I don't know if we can really, I don't think we can write this in, but so far we're still on a joint account that most of these monies are going to come out of to pay these bills, to pay the home, to pay the car. But from now to August 1st, I'm planning on paying this just as I have been, but there can't be any additional spending as there has been in this last month. And there has been, Ms. Nemec, so don't shake your head. You don't know about this. There has been additional spending and it has been unnecessary. And I'm footing the bill and I can't keep doing that. Beyond paying the home, the car, the insurance, there's Cedar Point trips now. There's, well, Ms. Nemec, I just paid you and I don't want to pay you, but guess what? It came out of the account. So I don't want to, I want that to freeze though. I want to pay the bills. I want to take care of the kids, but I don't want any more spending.
Your Honor, may I interject? There's a status quo in place that stays in place until the orders that were signed supplant those. The orders don't begin August 1st. They begin, I believe, July 1st.
I believe it's July.
Yes. The dollar amount that he will be paying, as I previously stated, child support is reserved for 1 year. We have a uniform child support order that will enter August 1st of 2025. He will be paying spousal support in a non-modifiable amount, and I'm trying to find it here quickly. He will be paying spousal support commencing July 1st, 2024 in the amount of $3,534.39 per month for 12 months. It was going to be paid directly no later than the first day of each month. And then commencing August 1st, 2025, he would pay spousal support in the amount of $1,100 per month for the next 18 months. Also commencing August 1st, 2025, he would begin to pay child support in the amount of $1,100 per month.
Yep. So Now we know
Right,
those
I just
things.
want to make sure that Mr. Frank understands that
I do.
spousal support does not commence August 1st. It commences July 1st of 2024. And until that time, the status quo order remains in effect.
Okay, so things that are above and beyond status quo that I'm not agreeing to, but that are just coming out of the account. And since it's my account, when it's depleted, I replenish it. I don't anticipate Leah just going on a spending spree, but at the same time, there's been several things that I have not approved that keep coming out of the account. And it's not, if it was, running to Walgreens and getting the kids medicine for $50, that's one thing. But right now in this time, we don't need to be taking $500 Cedar Point trips. I mean, it's just not the time.
Well, Mr. Frank, Cedar Point tickets would not be part of status quo. Those are over and above. So
I know
Ms.
they
Frank
are.
is purchasing those out of a joint account. She needs to restore those funds to that joint account. Ms. Nemec, that's the court's thought.
That my point is, I'm not trying to even get her to restore that. I'm trying to say, let's not do anymore. Okay. That's all I'm trying to say is I believe she understands that, but I just want to say
I understand.
I
Believe
believe
repeat yourself, Leah, because you were inaudible.
I said I do understand what he's saying, and I agree with that. And anything status quo, I agree.
Okay.
The problem is I wasn't asked, consulted. It just came out of the account. So you just can't do that going forward, Leah, at all.
Mr. Frank, you just heard Ms. Frank say that she understands and she agrees. So I believe that this matter is settled.
It was also understood and agreed to 2 months ago when I said stop the spending. And guess what? It's happened several times since. So
should not that joint account now be closed out?
It would be closed out once the spousal support starts being paid in July. We needed to get through the rest of this month. Ms. Frank is not employed outside of the home. Spousal support is going to be her only form of income for right now. While she navigates this new change in circumstance, Mr. Frank has repeatedly expressed that he wishes for her to be able to stay home with the minor children and not have to work outside of the home. But now
So the court stands corrected. Hold on. The spousal support starts on July 1st. Well, why can't Mr. Frank pay it? Why can't he close out that joint account so we don't have more withdrawals and expenses being paid out of the joint account, and we don't have to then argue about whether or not they're status quo?
Because then she would have no access to funds for the remainder of the month of June. It's June.
Why can't he pay? Well, the only obligation he's got is to pay her the spousal support for July, correct?
Beginning in July, if he would like to make that payment today, the $3,500.
That's not how that works, Ms. Nemec. The $3,549 is the total sum. I paid the bills, and then the bills are deducted from that $3,549, and she gets the remainder, which we haven't figured yet, but it's right around $1,000 a month.
The way it does not work, Mr. Frank, is that you be enabled to give Ms. Frank absolutely nothing for the month of June. The reason
that's not what I want.
This was part of a negotiated agreement that came from a mediation. And now what I hear Mr. Frank trying to do is change the terms of the agreement that was negotiated as a result of mediation in which he signed his name.
So one thing that wasn't addressed is spending up above and beyond the status quo. And
she already stated to you, Mr. Frank, that she heard you and she agreed.
And I stated to you that she heard me 3 months ago and agreed, and it's still
the matter has been addressed. She acknowledged what you were saying on a record before this court, stated she understood, and she agrees not to spend beyond the status quo.
I'm not asking for repayment either. I don't want that. I want to just make sure if I see something come out from Myers or Walmart or something that's a grocery, I'm not mad at that. But unnecessary spending. That's all I'm talking about, Leah. That's really it. And since you've agreed, I'm good with that.
And Ms. Frank has indicated she understands that and she does not disagree with you. In fact, she agrees with you, Mr. Frank.
Okay, we're good then.
All right. So again, Ms. Nemec, again, I'm looking at the judgment. Page 5 says spousal support. In answer to Mr. Frank's question, Mr. Frank is ordered to pay spousal support commencing July 1st, 2024 in the amount of $3,534.39 for 12 months. And then commencing August 1st, 2025, the spouse order should be reduced to $1,100 for 18 months, correct?
That is correct.
And you've attached to the judgment a uniform spousal support order.
There should be 2, I believe.
Okay, maybe that's from my confusion. Of course, there's a uniform child support order, and that, of course, provides child support will commence August 1st, 2025. There's a uniform spouse support order indicating spouse support should be payable in the amount of $1,100 August 1st, 2025. I want to make sure that second order is here.
We did have a hard time, Your Honor, getting signatures electronically on the 30th, and they had to be sent multiple times. And unfortunately, I don't have an executed copy in my file because I believe they all came over to the courthouse. I'm trying to find the electronic copy. There are so many copies of it because of the technological issue or the technical issues we were having that day.
Okay.
Is it not attached to what the court has received?
It appears we need a second uniform spouse support order. The one that indicates spouse support to be paid for the judgment in the amount of $3,534.39.
Your Honor, I'm sorry. It's because that first amount is to be direct paid. I'm sorry. I stated that multiple times. So that was not through front of the court. It was to be paid directly.
Thank you. Of course, that's corrected. This payment should be paid, made direct and no later than the first of each month.
Correct.
So again, Mr. Frank, in answer to your original question, I was just looking, there's a number of documents here. Your obligation under this term of this judgment, you pay spouse support and the amount of $3,534.39 for 12 months. You pay that directly to Ms. Frank commencing July 1st. And then,
Your Honor,
it'll come out of your paycheck commencing August 1st, 2025, when it goes down to $1,100 per month. And its child support is reserved until August 1st, 2025.
Right.
So we're all on the same page on that, correct?
I just so you know, the amounts are perfect, yes, but the way that the both things are structured, you know, the dollar amount of 35, 39, whatever it happens to be, is that total amount she gets for the month. And then all the bills come out of the account. That's the joint account that you see. So they come out automatically. You know, her car payment, all of it comes out, and whatever's left out of that 35.49 is what remains to her for whatever she needs, groceries, whatever, that's her business. So just so you know, the way it's structured is she doesn't just get a check for 35.49 at the beginning of the month and do whatever. So just so we're clear on that. And the second thing is I'm self-employed. So at the time where it's going to go through the front of the court in 2025, I'll have to work that out, how I get them that draw every month, if I take it in, or if it's, I think they do automatic deduction as well.
But not if you're self-employed, you pay that directly in front of the court.
Starting August 1st, 2025.
Correct.
I'm sure they'll be in touch before that point.
Okay, any other questions, Mr. Frank?
No.
Anything further, Ms. Nemec or Ms. Frank?
No, no.
I have nothing further. Thank you.
All right. Hopefully the parties will not be back in court soon. Ms. Frank understands and agrees with Mr. Frank's assessment of expenses being paid out of that account, which are not in the ordinary course of business. And with that, the court will sign the judgment and the uniform support orders, and that will conclude this hearing. Again, the pretrial conference of July 19th is vacated. All right, good luck, Mr. and Mrs. Frank. Now you can zoom out. Have a good rest of the afternoon.
I just haven't been able to get her. I signed my portion. I just need her to sign her portion, and I can have it into you today.
Well, how do you know your portion is acceptable to her?
She already signed her she already signed hers as well. Like signed like the first part of it. She just signed this last part.
There's just one judgment. I believe it's 2 pages. Did you both sign the bottom of page 2? Same document.
Believe she just needs to sign her portion, as far as I know, because I already turned in one judgment. I believe this is the last one that I had to turn in.
No, there's only one judgment, Mr. Teach Out. There's not multiple judgments. One, and it says top judgment divorce.
Okay.
So we sent you a form. We sent you a notice for this pretrial today. We sent you a form, judgment divorce. There's a label at the top that says you need to complete it, you need to sign it, you need to get to the other party.
Yep, that's the one I just needed. I need her to sign.
Do you have that document in front of you?
I don't have it in front of me. I have it. It was just my parents went to go get it signed just now. Like I just got off the phone with them 5 minutes ago. They showed up at her house and it was the wrong address.
Okay, so your parents have the judgment divorce?
Yes.
Are they coming back to your house in the next few minutes so you can have it in front of you?
I can call them and I can have them. They're out in town right now. I can have them come and bring it to me.
Well, let's get Courtney in here and find out what's going on. Okay, great.
Court is now in session. Derek Smith Teachout versus Courtney Frost.
For the record, this matter is before the court for pretrial conference. Same is being conducted via Zoom. And sir, you are Derek Matthew Smith Teachout, is that correct?
Yes, sir.
Is Courtney Frost present on audio?
Yes.
All right, good afternoon. Ms. Frost, so the court was just asking Mr. Teachout about judgment. We sent Mr. Teachout a form judgment divorce. It's a 2-page. You basically fill in the blanks and check the boxes. He indicates that his parents delivered that judgment to you. Is that correct?
No, I haven't received anything. The only thing I've received in the mail is the pretrial conference notice order for this call right now.
Okay, and with that pretrial notice, we have the Mr. Teachout, we sent him a judgment divorce saying, in anticipation of this, you need to fill it out, you need to prove it, you need to sit down with Ms. Frost or mail it to her. Both of you need to sign that document. So we cannot grant this judgment till that has been signed by both of you and returned. Is there anything at issue? Do you have real estate needs to be divided, joint debts?
No, we don't have anything like that. It should be a pretty cut and clean case.
Okay, is there anything in dispute?
No.
Okay. So, court can take some brief testimony. Mr.
I can meet her anywhere and have it signed today and turn it in today.
Why don't you come down to the courthouse? We'll print out another form for you. Come down here. Miss Frost, you live in town site, correct?
Yeah, I do live in town.
Okay, so you're just about 5 minutes away. Mr. Teachout, you live in Newport. Are your schedules
Is it
such that you can
possible
come?
to maybe have it? I'm so sorry. Is it possible to maybe have it scanned and emailed that I can sign it and return it? I have to leave for work pretty soon, but I don't have an issue to sign it and get it back like immediately.
Well, that's Mr. Teachout's obligation. And again, I want to make sure that you verify that's your signature.
Yeah, for sure. I mean, honestly, if he even, because I have.
Both want to come down tomorrow morning.
Yeah, I mean, I could do whatever works is fine.
Yeah, I can do it tomorrow morning as well.
Okay, you come down at 8:45 tomorrow morning.
Sounds good.
Yeah, that's fine.
Okay, 4th floor, Braunlich Court, 4th floor. Come up to the window. We'll have a judgment of divorce prepared. You can come to the window, get that. You can both review it together outside the courtroom, and then when I call the case, we can have you come to the courtroom at 8:45 and acknowledge your signatures. And we need to also verify, Ms. Frost, from your testimony tomorrow that you're not now pregnant. And will that answer be no?
Correct.
Okay, good. All right, we'll see you both then tomorrow at 8:45.
All right, thank you.
Thank you so much.
Mr. Walker from the front of the court.
Bye.
Also, before the court is the defendant's motion to modify parenting time. This hearing is being conducted via Zoom. President Attorney Henry Levens representing the plaintiff mother Taylor Kraft. Ms. Kraft is present. In addition, Attorney Maria Zagorski is present representing defendant father Luke Strazula, and Mr. Strazula is also present. I'm sorry. Good afternoon, everyone.
Good afternoon.
The parties have reached a resolution. Is that correct, Mr. Levens?
That's correct, Your Honor.
If you wish to, could you put the agreement on the record, please?
May I allow Ms. Zagorski to do that?
Yeah,
Okay.
Judge, I'm happy to do so.
Okay.
They're actually pending before the court are, as you indicated, my client's parenting time motion, a parenting time complaint, and plaintiff mother's motion for a friend of the court investigation of child support and other relief. We met with Mr. Walker and we were able to reach an agreement on all of the issues that are pending before the court. And I will be submitting a consent order. I'll draft a consent order that provides as follows. From today until July 15th of this year, the parties are going to continue their current parenting time schedule. Effective July 15th, their parenting time schedule will change so that plaintiff mother has every Tuesday, Wednesday, Thursday overnight. Defendant father has every Saturday, Sunday, and Monday overnight, and the parties will alternate their Fridays overnight. Once a month, mom may elect to exercise parenting time on a Saturday for an overnight. And when she does so, my client will have the following Tuesday overnight. So the parties will be exercising a 50-50 parenting time schedule. They are going to follow the front of the court holiday schedule unless they otherwise agree. And they've also agreed that each parent will be allowed to have 2 weeks of summer parenting time, which may be exercised consecutively. So one parent can take 14 days in a row. Mom will pick first in even numbered years. Dad will pick first in odd numbered years. And the person picking first for that year will make their choices by April 15th. The parties will continue to use AppClose for their communications. We are going to reserve child support effective today. So there will be a uniform child support order that'll be submitted with our parenting time order. Each party will be claiming one child. When only one child remains eligible to be claimed, mom will take that child in even numbered tax years. Dad will take the child in odd numbered tax years. They will share the cost of any uninsured out-of-pocket medical expenses 50-50. And then right now there's a prohibition against mom's boyfriend, romantic interest being around the children. That prohibition will be lifted 7 days from today on June 13th, provided that within 14 days from today, that being June 20th, mom and her romantic partner will provide letters from their respective therapists verifying that they are attending therapy and making progress on the issues that exist in their relationship. And should they fail to provide those letters within 2 weeks of today, that prohibition will be reinstated and Mitchell Iott will not be permitted around the children. And I believe that is the party's entire agreement.
Thank you, Ms. Gorski. Mr. Liebens, is that a correct statement of your client's agreement?
It is, with a couple of just additions. This will be a final order, so this will resolve all other outstanding issues. And mom has already elected by prior agreement of the parties her vacation time for this summer, a certain trip to Florida.
That's correct. She'll be going to Destin in August, and my client has already indicated he has no problem with that. I think it's 10 days. It's fine.
Very well. Mr. Struzula and Ms. Kraft, can you both please raise your right hand? Begin with Mr. Struzula, please.
Sure. Luke, would you please state, you can put your hand down. Would you please state your name for the record?
Luke Struzula.
You heard the agreement that I read into the record, correct?
Yes.
You understand it?
Yes.
And do you believe it to be in your children's best interests?
Yes.
You've participated in mediation this afternoon. Do you feel that all of your concerns have been addressed?
I do, yes.
And you understand that the judge would schedule this hearing, this matter for a hearing, take testimony, and would make an independent decision if you asked him to.
Yes.
But by entering into this agreement, the judge would sign off on an order and you would not be having a hearing. Instead, what we've decided today would be the order of the court. You understand that?
Yes.
Okay. Do you have any questions for me about any of the terms of the agreement today?
Nope, you've covered it all.
Okay. Thank you. That's all I have.
Thank you.
Thank you, Mr. Gorski. Mr. Liebens, do you have any questions, first of all, for Mr. Struzula?
Nothing at this time, Your Honor.
Questions for Ms. Kraft, please.
Ms. Kraft, same questions. You heard the proposed terms and conditions of this consent order that was just put on the record, correct?
Yes.
You've had time to think about it.
Yes.
You fully participated likewise in mediation.
Yes.
Do you have any further questions or concerns?
No.
You agree this is the best interest of your children?
Yes.
And are you satisfied with my services?
Yes.
And you wish the court to enter an order with these terms and conditions that are placed on the record to govern your affairs going forward?
Yes.
I have nothing further, Your Honor.
Thank you, Mr. Leibovitz. Ms. Gorski, do you have any questions of Ms. Kraft?
I do not. Thank you, Judge.
Who will prepare the order?
I will.
Thank you, Ms. Gorski. Very well, the court finds any agreement between the parents to be in the best interest of minor child. The court will accordingly adopt the agreement and enter the order upon presentment. The court would like to thank Mr. Walker for his fine assistance this afternoon, as well as, of course, counsel, attorneys Gorski and Leibovitz for helping facilitate ample resolution. So thank you. Good job, Mom and Dad. That will conclude this hearing. You can all zoom out. Have a good rest of the afternoon.
Thank you, Your
everybody.
Honor. Thank you, Mr. Walker.
Welcome.